Hi, good morning, good evening, everybody.
Yes, good evening.
Hi, it's 5:30. Shall we give it a few minutes to let everyone in before we start? Maybe another 2 minutes?
Sure. Haven't seen Miss Engineer Un. Engineer Un,
Hey, how are you?
good evening, good evening. Baru balik holiday.
Off the light. Off this light, on this light.
Right, you became invisible, is it?
Ha,
How was the holiday?
the light overshadows me.
How was the holiday? You went for holiday?
School holidays, so brought my kids and my in-laws all this okay for a short trip lah.
Yeah. School holidays. The children in the what? International school?
Wesley.
Okay, okay. Because the normal school holidays are not on yet.
Honestly, okay, you must have some school-going children. Okay, I don't know about this thing nowadays.
Yeah. Well, because
Janice may know later.
Janice was in Singapore celebrating some birthdays, is that right,
My
Janice?
daughter's birthday, so I already have a child, too.
Two, okay, good.
So child are not school-going yet lah.
Primary, so yeah,
What?
Primary
preschool.
already.
They're in Singapore?
No. Birthday. So I was there for work, so just brought them along lah, since it
Oh,
was also her birthday.
okay, great, very
Yes.
good. Yeah, I just celebrated my grandson's 1-year-old Sunday. Old people,
Congrats.
old people are having grandchildren around. Okay, Marshall,
Hello.
own. Marshall was briefing us just now. I think a bit of a repeat there, Marshall. You don't mind?
Yeah, sure. Basically now when I start the session, I will do a short welcoming to everybody and introduce the topic. And then I will also remind all the participants to put their name up, switch off their mic and camera. And then I will let them know about the Q&A to continue posting it in the chat box during the session. And I will be reading out the question and posting it to the panelists at the end of the session. So you guys can carry on the session and Q&A will be after. Basically, that's the run through of the session today.
And you would need about what, 30 minutes?
Maybe less. I don't know yet.
Okay, well, no worry. If we need to take a bit more,
If
we shall.
if engineer will need 1 hour, then Janice and I will just take 5 minutes lah.
Unlikely so, okay.
Okay.
All right. See that everyone is on, the participants are already on the session. I will just start now by welcoming everybody, all the participants, including the panelists to our session today. We're going to start. The topic today will be section 25, 26, 27 of CIPAA 2012, how to interpret and implement this in practice. So a warm welcome to our distinguished panelists. Thank you so much for taking out the time today to come and discuss this topic with us. For the participants, just a reminder to use your real name on the Zoom calls for our records so that we could award CPD points to you all after the session, and keep your mics and video off during the session. For Q&A, please post any questions you have during the session onto our chat box. We will compile the questions and post it to the panelists at the end of the session, so we won't interrupt the session and the flow. So without further ado, I'll pass the floor to our moderator, Engineer Leon, to introduce the speaker as we go. Thank you.
Thank you, Ms. Marshall. Good evening. My name is Leon Wing Sing. Again, very welcome to everybody on today's webinar. The key provisions of the CIPAA, which is known as the Construction Industry Payment and Adjudication Act 2012, we will be specifically focusing on section 25, 26, and 27. These sections, like others, promote the efficient process of adjudication proceedings, leading to a timely and impartial delivery of adjudication decision. We are thrilled to have you with us for this session. I was told there are two young Arif online. I extend my warmest welcome to them. Young Arif Datuk Lee and Young Arif Datuk Lim. We'll be diving into these critical sections that govern adjudication process and payment disputes in the construction industry. Now, to help us understand the nuances and practical applications of these provisions, we are joined today by three presenters who are well known in the construction sector. They are experts in the construction contracts and dispute resolution and adjudication processes. Engineer Un is an engineer, professional engineer, and he has a pool of engineering knowledge, very well equipped man. He will be guiding us through Section 25, A, B, C, J, and K, Section 26, and Section 27. After that, Miss Shirley Ho, will explore Section 25, subsection D, E, F, G, H, I, and Janice will deal with the rest of the section, L, M, N, O, and P. Now, we encourage you to ask questions throughout the presentation. As what Ms. Marsha has said, we'll pick up the questions at the end of the presentation, and the experts will address this at the end of the session. All right? Without further ado, let's get started. I will introduce Engineer Un. Engineer Un is a principal partner of his firm. He holds 3 degrees, not 1, but 3, namely a bachelor degree in civil engineering, bachelor degree in law, and a master degree in business administration. He's a former vice president of the Institution of Engineers Malaysia. Engineers Malaysia has got about 50,000 graduates, including professional engineers. He holds other posts in the said institution. Engineer Un was admitted to the High Court in Malaya as an advocate and solicitor in 1995. That's like, what, 30 years ago? And he's currently a member of various committees in the Bar Council, such as the Subcommittee on Arbitration and the Subcommittee on Construction Law. Engineer Un is also a fellow of the institution, as well as a Chartered Institute of Arbitrators. He sits on various committees in a CIDB and other bodies. He was at one time an external legal consultant to our JKR. Now he's known as a Kementerian Kerja Raya. Engineer Un has appeared as counsel in arbitration and litigation, some of which have been reported in Malaysian legal journals. He has also been invited to speak at various conferences and seminars on topics related to construction, and some of his articles have also been published in the Malayan Law Journal. Apart from that, he's also acted as mediator, adjudicator, and arbitrator, a well-known figure in the dispute resolution community. I now hand over to Engineer Un, who will be kicking off the session on the webinar. Engineer Un.
Thank you, Engineer Leon. Just how you say I'm well equipped. I'm not too sure in which aspects that I'm well equipped though, honestly. But you have inevitably, right, okay, revealed my age, an old man now.
But look young lah, look young.
Okay, in this session, we are dealing with sections 25, 26, and 27 CIPAA 2012. Their interpretation and implementation in practice. Now, what I am concerned with in today's brief talk in the 25 or 30 minutes, okay, which are allocated to me, okay, I will have what I will call a helicopter view on three principal topics. Okay, the first topic I want to deal with is to deal with a distinction between what is called a power and jurisdiction. Then this will be followed by a brief, and as I said, right, okay, a helicopter view of the ambits of sections 25, 26, and 27 of CIPAA. Then, okay, I'll briefly and glance through, right, section 25 A, B, C, J, and K of CIPAA. Now, the first topic about powers and jurisdiction. Now, section 25, as we all know, deals with powers, and section 25 itself gives a comprehensive list of powers available to adjudicators. But section 26, right, also touches on certain aspect of power, and which I may have certain question to ask on this. Section 27 deals specifically with jurisdiction, and this aspect of it, right, okay, has been quite controversial. Now, these three sections, 25, 26, 27, right, are what I would deal with, okay, in this very short 30 minutes. And I may trespass to other sections, okay. I hope my co-speakers, okay, will crave indulgence my co-speaker on this. Now, there's another section called section 24, which deal with the duties of adjudicator. Now, duties, right, as we all know, okay, has a twin called obligations. So, the funny thing is, okay, duties, the exercise of power, right, okay, brings with it certain consequences. But the breach of duties, right, by adjudicator, okay, bring about not to the adjudicator themselves, but to the effect of or the intellectual product, which is adjudication decision at the end of it. Now, I can't do better than to quote what Justice Jawawi Saleh said in Matego. Okay, he said, jurisdiction is everything, and without it, a court or an adjudicator has no power to take one more step. A court of law or an adjudicator downs its or his tools in respect of the matter before it the moment it holds the opinion that it is without jurisdiction. So this statement, right, a simple statement, but it's a very clear statement of what an adjudicator when faced with such a situations. And it also draw a distinction between power and jurisdiction. Once you have no jurisdiction, you have no power. And when you have jurisdiction under the CIPAA regime, then you can exercise the powers listed in section 25. Now, I can go on further on another statement by the former president of the Court of Appeal in what I may say is quite controversial aspect. Certain part of this case, right, may be controversial, which I'll discuss later on. Bill Weston, and this is what his lordship has stated: the distinction between jurisdiction and powers must be recognized. It is tried that they mean different things when both words appear in the same statute, i.e., the same situation here. Both the words jurisdiction and power appear within CIPAA itself. The significance of the divide between jurisdiction and power lies in the fact that jurisdiction relates to the type of subject matter which the court may deal with, whereas the power may be exercised only in relation to that jurisdiction. Now, that jurisdiction specifically relates to the very jurisdiction which has been conferred upon the adjudicator. So, these two statements by our apex court has very clearly drawn on the distinction between power and jurisdictions. Now, with that understood, let's have a helicopter view on what is the ambit of section 25. Now, Justice Lim Chong Fong, as he then was in the High Court, in the case of Anju Integrated Steel and Lim Chuan Hock, has made also a distinction between powers and duties of the adjudicator. And his lordship has specifically emphasized that Section 25 deal with powers and not duties. Now, the next question to ask is exactly what is this power? What is meant by the power? Now, power implies discretion, i.e., the power conferred on the adjudicator will allow the adjudicator to use his power under the Act or not to use the power under the Act. However, when you talk about power, right, okay, there can't be such thing called absolute power. There must be limit to the exercise of that power. So now the question is, what is the limit relates to the excuse me, what is the limit that will stop or cap the exercise of the power by the adjudicator? Now, just now we talked about duty and power, right? Okay. Now, this concept of duty, okay, does not relate to the exercise of power. The failure to exercise the power under Section 25 per se will not be a breach of duty by the adjudicator. And as I said just now, right, okay, power implies discretion. That means the power under Section 25 can be invoked either by the adjudicator himself or herself or by the adjudicator according to parties or parties' request. That means either the adjudicator can he himself on his own accord or her own accord exercise the power under Section 25 or upon the request by either one or both parties to exercise the power. Now, Section 25 gives a very comprehensive list of the powers available to the adjudicator. And what Justice Mary Lim, in her leadership decision in WLP Asia Pacific, said the powers relate substantially to administrative and procedural matters that will better promote the more efficient conduct of adjudication and adjudication proceedings. Now, I specifically underline the word substantially there because her ladyship has been very careful with her words. Because if you examine all the list of powers in Section 25, not all relates to administrative and procedural matters. For example, the power to award financing costs and interest. This does not actually relate to administrative or procedural power. And the power to open up reviews and revise certificates. These are not exactly administrative and procedural power. But having said so, right, okay, her ladyship, as stated by her ladyship, Justice Mary Lim, most of the powers under Section 25 are either of administrative and procedural matters, okay? Now, other than those lists of power under Section 25, right, there may be powers in other sections of CIPAA itself. For example, Section 14 on the powers to consolidate two or more adjudication proceedings, but it comes with a caveat. The adjudication proceedings must be of the same subject matter and before the same adjudicator. Okay? And Section 19.1, there's a limited power to agree on the adjudicator's his or her fees with the parties. And of course, if there's no agreement, right, AIAC standard terms of appointment and fees shall apply. Now, how about any other powers other than those provided for in Section 25? Now, we can make a comparison to the powers of an arbitrator. Now, we all know the concept of competence of the arbitrator in arbitration, i.e. the arbitrator, right, has a power to finally decide on his or her own jurisdiction. But there's no such provision in CIPAA 205. Sorry, 2012. Therefore, can this power be available to the adjudicator? And also, the adjudicator has no power to order for security for cause. There's no such provision in CIPAA. And also, right, can an adjudicator, like an arbitrator, have the power to correct accidental or arithmetical or clerical errors. Take, for example, if the adjudicator, after having sent out his or her adjudication decision, discovered or put on notice by the parties or one of the parties that there are some computational mistakes in his or her decision, does the adjudicator have the power to correct such computation or other clerical errors? For this, right, okay, maybe we can look at this, so something called, is there such a thing as implied power conferred onto the adjudicator? If no such power is not if no such power is conferred onto him or her under CIPAA 2012. Now, to answer this question, right, I think we have to make a distinction, and those cases in England have to be studied with some care, because unlike adjudication in England, where the powers are contractually conferred, under CIPAA 2012, adjudicated powers are statutorily conferred. So a distinction must be made there. So if the powers under CIPAA 2012 are statutorily conferred, it is arguable, and in fact, I think it can be argued with some persuasion, that such concept as implied power does not exist. Now, just now, right, okay, I talked about there must be kept in the exercise of power by the adjudicator, and what are the limits that can constrain the exercise of adjudicator's power. And of course, one thing that springs to mind is natural justice must always be upheld and be adhered to. And of course, the adjudicator, right, cannot exercise power to an extent and to be outside the regime of CIPAA. And the exercise of power, right, must be in accordance with the intent and purpose of CIPAA. Maybe one can even argue that to contract out on these powers, right, okay, may be a case of contracting out of the regime of CIPAA itself. So, with such the extensive list of power given to the adjudicator, right, maybe a reminder will need to be given. This picture here shows someone called Uncle Ben. And if you all can look at the picture on the right, that is Peter Parker, Spider-Man. And Uncle Ben is Peter Parker's Spider-Man's uncle. And before he died, he said to Peter Parker, with great power comes great responsibility. So I think that is a reminder to the adjudicator. Now, that is a helicopter view of section 26, section 25. Now, let's have a look at section 26. Does section 26 confer another power onto the adjudicator? Now, section 26 is a unique provision not found in any other security or payment regimes in other parts of the Commonwealth. Okay? Now, this section 26, right, allows the adjudicator to ignore, or colloquially, like, okay, close one eye, if there's no non-compliance by the parties. It must be stressed, by the parties, not by the adjudicator himself or herself, by the parties, to non-compliance with CIPAA 2012 with respect to, as the provision says, time limits and also form of content. But the funny or quite unusual provision in section 26 is that when there's such a non-compliance, the arbitrator, right, seems to have no choice, because section 26.1 specifically says such non-compliance shall, not may, shall be treated as an irregularity. Now, those of you who who read court the rules, okay, to the rules of court, okay, under order 2, right, you know that, okay, when it is treated as an irregularity, right, that means it's not fatal. Your course papers is not fatal. So similarly, right, if you take the word irregularity to have that meaning, that means non-compliant by the parties on time limits of formal contents as provided in CIPAA itself, right, it's not fatal. So it does not mean that there is an end to the CIPAA proceedings. Now, if you look at that, it says, Section 26(1) says, time limit by the parties, and I stressed just now, okay, time limits, right, okay, this does not and does not extend to the non-compliance to the timelines as laid down, for example, in CIPAA for the adjudicator to deliver his or her decision. Now, time limits by the parties, time limit in serving adjudication claim, adjudication response, and reply. Now, there are time limits, of course, okay, 10 working days, 10 working days, and 5 working days in serving each of these 3 documents. Now, I can't think of any others, to be frank. So, the next thing is, if the adjudicator has exercised his or her power in Section 25, can it be, in a way, be covered by this Section 26? I would suggest that is so. And okay, as I said just now, right, okay, this concern with non-compliance of time limit by the parties and not by the adjudicator himself, herself. Now, when you talk about form or content, okay, does it relate to documents submitted? Now, also, right, okay, does it extend to the submission of payment claim and payment response as contrast to adjudication claim and adjudication response? To this later part on payment claim and payment response, okay, my considered view is no, it does not. Now, if you read Section 26(1) in a little bit more detail, right, okay, other than time limits, right, and form of content, okay, the sections also specifically say non-compliant in any other respect. That has very much widened the non-compliance aspect of the CIPAA 2012 in respect of any other respect. And if you read it in that manner, right, in the literal meaning of this phrase here, in any other respect, it will make, for example, the timeline for the submission of the documents too flexible, way too flexible. Now, again, just now, okay, when you talk about the power under CIPAA 2012, okay, too flexible an interpretation will very much defeat the intent and purpose of CIPAA 2012. Okay, if you look at the preamble to the Act, which must be taken into the purposive interpretation of the Act itself, it says, the purpose of the Act is to have speedy dispute resolution through adjudication. So, even though these words here, in any other respect, seems very wide, it is my humble submission that it does have its limit. Now, Section 26, after this non-compliance with the timeline or the form of content, right, okay, under Section 26(1), and as I said just now, it is not fatal. What can the adjudicator do next? Okay, so 26(2) provide provision for what the adjudicator can do. But does Section 26(2) actually relate to Section 26(1)? Now, let's look at 26(1) and 26(2). 26(1) talks about non-compliance by the parties with the provision of this act, whether in respect of time limit, form, or content in any other respect, or in any other respect. That is what Section 26.1 says. Now, Section 26.2 says, non-compliance in respect of the adjudication proceedings or document in singular produced in the adjudication proceedings. So now one relates to time limit, form, or content. The other one, Section 26.2, relates to adjudication proceedings or documents produced in the adjudication proceedings. Now, if we read the two widely, right, okay, it does suggest some connection and some causal link. Firstly, what is meant by adjudication proceedings? Now, in Section 4, define adjudication proceedings as the process of adjudication. Now, when Section 26.2 said that adjudicator can set aside the adjudication proceeding, what does that mean? Does that mean that to set aside the adjudication claim, or the response, or the reply? Now, as I said just now, right, okay, it does not include payment claim and payment response, okay, in this case, because number one, right, the documents were served or filed even before the appointment of the adjudicator. And number two, by way of Section 8.1, adjudication proceedings only commence by the serving of a written notice of adjudication. And this, right, okay, written notice of adjudication was served after payment claim and payment response have been filed. Now, so it is a question of power duty. And the next question that can be asked is, can the adjudicator's action or inaction pursuant to Section 26 to be reviewed by the court? Following from the court decisions, right, so far, okay, and taking a cue from the exercise of the power under Section 25, I think the court will be slow in interfering with the adjudicated actions or inaction pursuant to Section 26. Now, quickly I want to deal with Section 27. Okay, 27 specifically deals with the jurisdiction of adjudicator. Okay, we have discussed the distinction between jurisdiction and power just now. Okay, and when you talk about jurisdictions, right, okay, it relates mainly to Section 15 on setting aside adjudicant decision, i.e., when an adjudicator has exceeded his or her jurisdiction, the decision can be set aside upon application. However, Section 25 deals with exceeding jurisdiction, but there is such a thing called there's lack of jurisdiction in the first place, and this has been emphasized by our apex court in due esteem, where the court does make a distinction between absolute lack of jurisdiction and the excess of jurisdiction. Now, contrary to the clear wordings, right, due esteem case has established that adjudicator must consider all matters raised in adjudication claim and adjudicant response, irrespective if certain matters, right, has not been raised in adjudicant response. Now, the court has gone on to say that, okay, it is a breach of natural justice if the adjudicator has failed to respond. So, excuse me, if the adjudicator has failed to decide and deal with the matters raised in adjudicant response, which has not been earlier raised in payment response. Now, this word here, matter, right, okay, as far as I know, this word matter here has not been touched on by any judicial decision in Malaysia, and I stand corrected on this. And if there's any possible guidance on this, okay, maybe you can have a look at the UK Supreme Court's decision in the Republic of Mozambique and Privinvest shipbuilding, okay, where the Supreme Court UK has given guidelines as to what is the meaning of this word matter, but in the context of Arbitration Act 1996 England. Now, there is tripartite classification jurisdiction, and by Justice Lee Sui Sing in a High Court case of Terminal Parentis and Tan Nghi Hong Construction. I have done a search myself and think this must be one of the most cited cases in CIPAA. Okay, now this case here, where His Lordship has very helpfully and very influentially laid down three classifications of jurisdiction: core jurisdiction, competent jurisdiction, and contingent jurisdiction. I think this is well known to most practitioners of CIPAA, and I will not go into it as what they denote. Now, Section 27(2) deals with extending the jurisdiction of the adjudicator, and the extension of the jurisdiction must be by agreement by the parties in writing. Now, the next question to ask is, can the adjudicator's jurisdiction be extended to non-payment disputes? Now, we all know that CIPAA only deals with payment disputes, but can the parties by agreement extend the adjudicator jurisdiction to non-payment disputes? For example, can the parties, right, okay, by agreement, ask the adjudicator to come to a finding where the time for completion has been set at large, or claim for damages which are not within the province of CIPAA? Or can those residential construction buildings not within the purview of CIPAA by virtue of Section 3, right, be by agreement of the parties to come within the jurisdiction by agreement of the parties? Now, Justice Wong Kin Keong, right, in this Shah Alam High Court case of Integral Acres and BCEG International, has stated, and I must stress, okay, this I believe is an orbital statement, that, okay, yes, it can be done. However, right, okay, I want to pose a question further. Can the adjudicator's jurisdiction be extended to payment disputes or non-payment dispute or both, which has arisen from another construction contract by the same parties? So the question now is, it is quite controversial, but if I am asked to state the view, right, my answer will be answered in the negative on these issues. By agreement of the parties, right, outside the province, outside the CIPAA regime, effectively, right, okay, is to contract out of CIPAA itself. That's my considered view. Now, the next thing is, when can jurisdiction challenge be raised? We all know jurisdiction of the arbitrator, right, must be raised not later than the filing of the statement of defense. But in this case here, right, okay, under excuse me, in CIPAA, if you look at Section 27(2), jurisdiction to be extended by the parties at any time. Okay, so does it mean that jurisdictional challenge can also be raised at any time? Now, jurisdiction may under 27, okay, as I said, okay, is statutory conferred, therefore the concept of waiver does not apply. Okay, and to answer when can it be raised, okay, my considered view is yes, it can be raised at any time. Now, if I can make a straight comparisons, okay, I've said, okay, there's no competence in CIPAA 2012, and with, even if there is an educational challenge, right, sorry, a jurisdictional challenge, the adjudicator can still proceed with arriving at his or her decision. The next thing being, what if the adjudicator finds that he or she does not have jurisdiction, whereas he and she in fact has it? In such a case, okay, there is decision to the effect that that part of the decision can be enforced and the rest, right, okay, will be ignored. Now, the next thing is, will the court interfere before or during adjudication proceedings when jurisdictional challenge is raised? For example, will the court interfere with the grant of an injunction, for example, okay, or the grant of injunction, right, to prevent the initiation or even the continuation of adjudication proceedings? Now, Justice Lim Chong Fong has very helpfully given us this case here on Magnate Equity and Prestige Mega, where His Lordship has said the grant of injunction will be sparingly granted, but exception, or the only exception, will be when there's a lack of core jurisdiction of the adjudicator, or what His Lordship said, there's a lack of adjudicatability of the claims when the facts are not in substantial dispute. I believe this word has gone into the CIPAA lexicon, the adjudicatability in our CIPAA regime. Now, quickly, right, Section 25A deals with the power of the adjudicator to establish a procedure in conducting the adjudication proceedings, including limiting the submission of documents by parties. Now, this, right, okay, section effectively renders the adjudicator the master of the procedures of the adjudication proceedings, and to order discovery and production of documents, set deadlines for the production of documents, and very much all-encompassing, issue any direction as may be necessary or expedient. This effectively, okay, facilitates the exercise of the powers under Section 25, those that deal with procedural and administrative matters. And there's what I would think is quite a peculiar power, order interrogatories to be answered. I myself have not encountered this in practice, either as an adjudicator or as a counsel in adjudication. I leave it to all the parties. And with this, thank you very much.
Yes, thank you, Engineer Un. Engineer Un, are you a lawyer or are you a surgeon? You dissect the act like having an operation.
Oh, the title is IR Unchiking.
Not a DR yet, huh? Okay, that's a very insightful dissection of the various sections, very helpful. And I believe that Engineer Un has given us some very general guidelines as well as specific guidelines in the use of the various sections, especially the jurisdictional area. That's very helpful. Now, we'd like to move on to Ms. Ho Shirley, and she'll be looking at subsequent sections. Now, Shirley is a partner of Raja Dara and Low. She's in the construction sector, the Infrastructure and Energy Practice Group of RDL, and she's recognized as a leading individual in construction law in the Legal 500 Asia Pacific, a distinguished practitioner from dispute resolution, construction, infrastructure, and energy works, and a ranked individual for construction works in Chambers Asia Pacific. Aside from her busy counsel practice, which covers both court and arbitration proceedings, she has also developed an area of work related to construction dispute management, namely the management of industrial incidents, health, safety, and environmental issues. All right, so we welcome Ms. Ho Shirley to get on with the second session. Thank you.
Thank you very much, Engineer Leon, for the kind introduction, and thanks to everyone for having me here. So I would take over the screen. Sorry, can I just do a check if the slide is up on the screen? All right, great, thank you. All right, so I'll be dealing very specific only on section 25, but in particular from D to subsection D to I. And what I've done is I've kind of just set it all out, and I thought some of these sections are most of the time when we look at the cases, they are actually taken together because of the nature of these provisions, these powers. So I will be talking about section 25D and 25I together, and thereafter I will be addressing section 25F and G, and then section 25E on its own and section 25H on its own. And just as an overview, as you can see, section 25D and 25I, most of the time they are taken together because they are kind of overlap in terms of this power. Basically, it's allowing the adjudicator to have the power to draw on his own knowledge and expertise, and also to be able to take the initiative to actually ascertain facts and the law required for the decision. And then when we look at 25F and G together, again, this would be powers relating to calling for meetings and hearings. And then E on its own would be where the adjudicator exercise the discretion to actually appoint an independent expert to inquire on some specific matters, but of course with the consent of the parties. I think this would be the provision that is least seen in terms of the case law. And lastly would be 25H, whereby the adjudicator can also exercise the power to carry out inspections, including opening up any work done. Again, not that many cases have discussed on 25H. So therefore, the cases that I'm going to be sharing and discussing in a couple of minutes are mostly on section 25D and I, and section 25F and 25G, right? So let's start off with the first one, 25D and 25I. But before I go on to this, I think one of the observations we make is that, of course, most of these cases that have gone on to court, they are essentially cases that are dealing with setting aside under section 15, which I think most of us are very familiar in terms of the provisions under section 15. And I think the most that is being referred to under section 15 would be the provision on the breach of natural justice. So when we are looking at these powers exercised by the adjudicator or not exercised by the adjudicator, we are really looking at how this has an impact that can then amount to a breach of natural justice that eventually runs out of section 15 and liable to be set aside. That's essentially how we look at it. And I think another point to note is that when we look at this exercise of the powers by the adjudicator, I look at it as an adjudicator versus as a counsel representative for the party. How do you actually deal with this provision, right? So for example, if you are the adjudicator who actually wants to exercise this power without either party calling for it, right? What would be your considerations when you want to do that? Then on the other hand, if I'm acting as a counsel representative, I would then be looking at how can I persuade the adjudicator in a most effective way that can convince him that he should exercise that particular power to allow this to be done. So that's how I look at it. So let's just look at some of the cases that have come up in court and how these sections, these provisions have been dealt with by the court. In this case, Pasukan Khas Sdn Bhd against Empire Multiple Sdn Bhd. Again, this is a case where section 50, argument on breach of natural justice, adjudicator went on the floor of its own, dismissed the claim based on factors not put forward by the party. I think that sort of argument, it's just really, most of the time we're seeing all those arguments being raised in most of the cases. It's about adjudicator go on its own folly, never considered certain things, or give the parties equal chance to address the adjudicator, and therefore the losing party will then say that is a breach of natural justice. So that's how we've often seen this sort of argument come up in court. So in this case, again, what happened was the adjudicator dismissed one part of the claim. Basically, it's not allowing the settle, and in that same paragraph, the adjudicator actually stated that in any event, he made the observation that the retention money being held by the respondent would be more than sufficient to deal with those costs, i.e. the claims that he's not allowing, and even if the claimant eventually found to be liable at subsequent stage. Now, because of that observation that he made about in any event, there is enough retention sum that can take care of the claim, if assuming it goes on to a further forum later. Because of that, then it was being accused that means that he has considered something that is beyond what the parties have put forward. So therefore, that should not be a consideration. And because he considered that, that is actually a breach of natural justice. Now, of course, the court said no. The court make it very clear that the adjudicator has first decided to dismiss the claim first. And he then makes that observation, and the word used is in any event. The retention sum or retention money currently being retained by the respondent is more than sufficient to deal with those costs. And that is just merely an observation to say that the respondent eventually is not at risk about those costs that is not being awarded in his favor in this adjudication. So that is just purely an observation. But we could see how parties would use this sort of argument to kind of run the argument that it's not the adjudicator has considered something beyond what the parties have put forward. Okay. Next case, this is terminal parentis, which Engineer Woon has also referred to this case earlier. But I'm only focusing on this very small part where we touch on section 25D and 25I. So the question is whether there has been a breach of natural justice, again, this same argument, because the adjudicator referred to some case law that were not cited or referred by the parties, right? And of course, in this case, the court said no, that was not a breach, because if you look at these cases that the respondent is complaining of, that he has no opportunity to submit on or address the tribunal, the court note that these cases were merely setting out basic proposition of the law. So therefore, the court took the view that even if you look at the cases, it's not going to make a difference or an impact to the outcome of the decision. And of course, in saying so, the court made that observation that section 25D allows the adjudicator to draw on its own knowledge and expertise, and under section 25I, to take the initiative to ascertain the law required as well. So therefore, in this case, the court was not satisfied that there was a breach of natural justice for those reasons. Again, this is just my observation from this reading this. My take is that if we are as a counsel, or sorry, as an adjudicator, if we want to consider cases beyond what the parties have referred to, of course, it's always a good idea to sort of inform the parties and allow them to address you on those cases. I think that perhaps is a safer course. But of course, we're also mindful that sometimes it could just very well be a situation where the adjudicator wanted to write a more coherent a judgment that it requires some basic proposition of the law to be set out, and just unfortunately perhaps the parties did not get onto as basic as those case law that tells us the basic proposition of the law, and therefore the adjudicator took it upon himself to sort of just make reference to those cases. So I appreciate that can happen, but of course the safer way would always be go back to the parties and say, look, could you just please address me on these cases. So I think that perhaps would be helpful. And then another case I'm going to look at is this Tenaga Nasional Berhad against MRCB. In this case, what happened was the adjudicator actually ruled in favor of the contractor. And this has to do with the claim on this screening work, whether that is additional work or it's actually a rectification work. But because the adjudicator, it's well versed with the practices, so to the adjudicator's mind, if this is indeed a rectification work and not an additional work, we should be seeing documents like a non-conformance report, NCR, commonly known as NCR, For any other side memo, that sort of document, complaining about the work, asking the contractor to come back and rectify. But because we don't see that, so therefore the adjudicator took the view that he's not satisfied that this is actually a rectification work, but rather instead it's actually additional work. Now, of course, then the complaint, when the matter went up to court for setting aside, again on breach of natural justice, is that the finding on not having an NCR, which is a non-conformance report, or any other document, that issue was not raised or put to the parties for the parties to address the adjudicator. So in that sense, he went on his own frolic and decided on this point. Of course, the court was not agreeable, or rather was not accepting that argument, that line of argument, because again, the court go back to the powers of the adjudicator under Section 25, that it is entirely within the power of the adjudicator to actually draw on his own knowledge and expertise. After all, he is actually appointed, and he has gone through all those qualifications to ensure that he's actually a suitable candidate to be on the panel, and the fact that he's being appointed to hear this dispute, and there is power afforded under Section 25, it's entirely up to the adjudicator to use that, to use his own knowledge and expertise to actually determine the dispute. So the court declined that to interfere and set aside the decision. Of course, the court was also mindful to make a point that in any event, the parties were given ample opportunity to address the adjudicator by all the documents submitted before the adjudicator. So there shouldn't be any complaint about not having the right to be heard. So that essentially wrapped up the Section 25 D and I. I'm going to move on. I'm mindful that we're running short of time. I'm going to move on to Section 25 F and 25 G. These two provisions, basically it deals with the power to call for meetings or conduct hearings and limiting the hearing time as well. Again, these provisions are, we see a lot more being raised in court, in cases in court, when we look at the powers under Section 25. So in this case, SQA builders, this is also a case that's been quoted cited and referred in a number of cases, subsequent cases. In this case, basically there was a complaint that the respondent was not given the chance to be heard. But what was very peculiar was in the affidavit in support of the application to set aside, it was not very clear. There was no exact reason cited in support of this ground, because the fact appears to be that there was no specific request made by either party during the adjudication for an oral hearing to be conducted. So it remains unclear what is the basis for the respondent to argue that it was deprived of the chance to be heard. But nevertheless, what was observed in that case was that, of course, the court did not agree that there was any breach of natural justice. The court made that observation that, I think first and foremost, there is no automatic or inherent right for an oral hearing. So just because you ask for an oral hearing, it doesn't mean that the adjudicator must grant you the oral hearing, okay? And neither can you then run the argument that because I asked for it and I was not given the opportunity to be heard orally, therefore there is a breach of natural justice. That argument doesn't work. Now, of course, if we just take a moment to then compare that with the arbitration under the Arbitration Act in Malaysia, whereby we know that there's this document only arbitration where hearing can be dispensed with if it's suitable. But if one party requests for an oral hearing, the arbitrator is duty bound to hold oral hearing. And that sort of provision is very different because it's expressly stated so in the Arbitration Act. But we don't see that sort of provision or the wordings to that effect in CIPAA Act. So it's very different. Therefore, ultimately, it is for the adjudicator to decide whether in that case oral hearing is appropriate, whether it should be carried out, and the manner in which it is to be done. So in this case, the court also made the observation that it would be slow to interfere with the way the adjudicator went about in conducting the hearing, unless it is unfair or blatantly a breach of natural justice. That means it's so perverse that, and it resulted in an outcome that no reasonable person sitting in his position would have decided. I think short of that, the court will not interfere with that discretion. And of course, another very important point observed in this case is that court also make it very clear, oral hearing is not a requirement of natural justice. So you can't say no oral hearing means there's a breach of natural justice. That equation doesn't work. And then we're going to go on to the next case, which is McLee Equities Sdn Bhd against Prestige Mega Construction Sdn Bhd. In this case, again, it's about conduct of oral hearing. Basically, in this case, one party requested to orally submit on the issue about the CNC validity as well as the EOT granted, because the respondent alleged that this has got that impact on the claim for LED, which is part of the respondent's defense in the adjudication. So the question is, the fact that that request was rejected, does that mean that there has been a breach of natural justice? Court said no. In this case, the court actually gave the opportunity for the parties to address the adjudicator on why there's a need to hold oral hearing. And after listening to the parties, the adjudicator then decides that no oral hearing will be held, and the matters referred, would not be prejudicial without an oral hearing to the outcome of the case. So he decides, the adjudicator decided not to allow oral hearing. So when it went to court for setting aside and this issue being raised again, the court make it clear that it would not review the merits of holding an oral hearing, because this is a matter entirely within the discretion of the adjudicator under Section 25 G, whether or not oral hearing ought to be conducted. And the last case we're going to look at for these two subsections would be this case, Guangxi Development, that has gone on appeal. This is very interesting. Again, there was a request for oral hearing, and the adjudicator rejected the request for oral hearing. And I list down these 3 points that was noted, and I think this is very interesting. So the reason for rejecting that request was because the adjudicator observed that there's a limited time under CIPAA for the adjudicator to deliver the decision. So in other words, time constraint. Point number 2, because the dispute has already been referred to arbitration, so no prejudice, because these witnesses can still be called in the arbitration proceeding to testify. So you won't be prejudiced. Number 3, of course, this is the previous position. Defense for disputing the payment record was not raised in the payment response. So in other words, this particular point, this defense was not raised in the payment response, and therefore it cannot be considered. Of course, it is under the old position. So, and let's see what the court says. Now, the court said in this case, there has been a breach of natural justice for rejecting the request for oral hearing. And if you compare this with the other first 2 cases that I referred to, there is a clear distinction. In this case, again, if I go back to the reasoning number 1 is because the adjudicator felt that because time constraint, CIPAA run on a very rigid timeline, so no time, so oral hearing is not suitable. Anyway, no prejudice, you can still have your witnesses testify in arbitration. So these sort of answers or reasons are not good enough. It cannot convince the court that that is a good reason for rejecting a request for oral hearing. And in this case, in the Court of Appeal, the Court of Appeal makes the observation that any application for oral hearing must be considered on its merit. So if you contrast that with the 2 cases that I cited earlier, where I said the court will respect and will be slow to interfere with that discretion, that does not mean that the court will never interfere. The court does look into the case on its own and look at the merits, whether that rejection, whether the reason given it's appropriate, it's reasonable. So the court does look at the reason for rejecting a request for oral hearing made by the party. And in this case, the court also observed the timing in which the request was made. In this case, the request was made just 1 day after the service of adjudication reply. And in other cases where the request for oral hearing was made much later, then the court may take that into account and as one of the reasons to agree with the adjudicator for not allowing it. So in terms of timing, that is also a relevant consideration. And finally, on that point about this witness can be called in arbitration and testify later, the court makes the observation that this is not a convincing argument just because the witness can be called to testify in a separate proceeding. That is not a good argument, because you are saying that if the appellant would end up having to pay first and then to have this argument to be ventilated later on. So that is not good enough a reason to reject a request for oral hearing. So in this case, the Court of Appeal held that there has been a breach of natural justice. So this is a direct contrast to the other two cases that we looked at earlier.
Shirley, excuse me, Shirley, can you wrap up in 2 minutes' time?
Okay, I will. All right, so I'm going to go on very quickly to 25E. I would just say that, look, there has not been that many cases. In fact, I've only come up with this one, Ghazri's Sinran against Hasrat Gemilang. This is not an application challenging about rights to be heard. It's more of the appointment of adjudicator. So the complaint in this case is that the adjudicator is not competent, has not properly passed the test because he's a practicing lawyer but doesn't have the working experience in construction industry. So that is essentially the complaint. So when the court look at this point, the court just makes that observation that that is not really what is needed for this case. There's no requirement to go into the technical details of engineering in this case. But even if it required that sort of understanding, it shouldn't be a concern, because Section 25E allows the adjudicator to appoint an independent expert to inquire and report on specific matters, and to address him. Of course, this is with the consent of the parties. So that is how 25E was being discussed or picked up in this case. And I'm going to move very quickly to 25H. This is on the power to carry out inspection on work. Again, it's a power that can be exercised by the adjudicator. So in this case, Zana Bina, again, Cosmic Master Development. In this case, what happened was that the adjudicator exercised the power to conduct an inspection. In fact, the claimant was not keen and didn't even turn up at the inspection. And subsequently, the adjudicator decided to reject the respondent's expert report because he found that the findings in that report did not meet the terms, the rate did not meet the terms and conditions of the contract, and also it exceeded the claimant's rectification work. The valuation basically is not proper, so he rejected the report and found it in favor of the claimant. So one of the complaints is that there's been a breach of natural justice because adjudicator did not disclose his findings following the inspection. And in this case, the court said, no, that is not an argument that you can raise to argue that it's a breach of natural justice, because adjudicator basically has no duty to disclose his findings in that sense, because that falls within the realm of finding of facts, and the court will be slow to interfere in that sense. So I think that wraps up Section 25H. Yeah, that's the end of my sharing. I'll pass the time to you, Ayalian.
Yeah. Thank you, Shirley. I will not summarize what you have presented. I will move on to Janice, Ms. Janice Tay. Janice has a very impressive CV. She's a head of the International Arbitration and Construction Engineering teams and a partner of Wong in the dispute practice group at Wong Partners, Baker and McKenzie. She is a qualified arbitrator, adjudicator, and mediator, and panel with several institutions. Her portfolio includes litigation with appearances in all levels of court. Recognized in the Legal 500 Arbitration Power List, Southeast Asia 2022, Chambers Legal 500, and various notable directories, she is praised for her meticulous and articulate approach. Janice was the president of the Society of Construction Law. She currently sits as the president of CIPAA YMG Group, secretary of Women in Construction and committee member of CIPAA and the Bar Council's Arbitration and Construction Committee, among others. She leads her firm's pro bono unit, involves in several diversity initiatives, and enjoys training advocacy with the Bar Council. She'll be taking us through the rest of the Section 25, which is Section 25 L, M, N, O, P. Over to you, Janice. Thank you.
Thanks so much, Leon. Okay, can everyone see my slides? Yeah?
Yeah.
Okay, thanks, Shirley. Okay, look, I'm mindful of the time. I know you all have questions, so I'm going to run through these very quickly. Because you will be getting the slides later on, so you will be able to see the cases that I'm going to refer to. Secondly, I have no Peter Parker here, but I do have Christmas colors for you, so Merry Christmas in advance. I'm just going to quickly go on now. Now, the first thing I'm going to deal with is just an overall on how these powers are to be dealt with. I think Mr. Un has already said these are powers, not duties. And I just want to echo what Mr. Un and Shirley has said. These are essentially powers. The adjudicator is not obliged to use these powers. But if you do use it or if you don't, that has always to be seen in the lens of natural justice and jurisdiction. So that is always, I think, the weakness of any adjudication decision. And if you, as the adjudicator, is adjudicating on one case, that you have to be mindful on how exercising these powers are going to affect the parties. And essentially, these are cases that echo it. You know, you can't use it in a way that is grossly unfair or perverse in the circumstances of the case. And the court essentially would look at the ultimate decision and see whether it's acceptable to setting aside for grounds set out in Section 15 of CIPAA. So that is the main thing to be considered when one is utilizing powers under Section 25. All right, 25L, order evidence to be given on oath. Now, what evidence is this? An adjudicator can call a witness to give evidence or can order documentary evidence to be produced on oath. Now, what happens if the witness refuses to give such evidence or a party refuses to give documentary evidence? There is authority to say that the adjudicator can draw an adverse inference against that party. Okay, and I put there the Evidence Act, which essentially explains what adverse inference means. But basically, the court is able to presume the existence of a fact, right? If one refuses to adduce this evidence. Wong Huat is a case where the court has echoed this, where essentially the adjudicator wanted certain information because the adjudicator thought that it may assist the adjudication process. Now, the information related to the main contract between the main contractor and the employer. And the respondent basically refused to furnish it because they said it's irrelevant. The adjudication is essentially before the main contractor and the subcontractor. And the contract actually had a bar on this. And of course, the court said, look, at the end of the day, it was open to the adjudicator to draw the necessary adverse inferences, although that did not happen in that instance. Now, if an adjudicator wants to draw adverse inference, it might be appropriate to give advance notice of such a possibility. Again, the whole idea is to be fair to the parties, to give them notice, to warn them that this might be the situation so that they are not caught by surprise. Balfour BT is an English case, and the court basically said there that an adjudicator can draw an inference and the adjudicator would not be subject to criticism, but it might be appropriate to give advance notice. So something to bear in mind. Now, Section 25 M and N, I'll take it together, basically talks about the certificate, the adjudicator is able to review and revise any certificate and declare or decide on a matter, notwithstanding no certificate has been issued on a matter. It is very, very common, you know, if a contractor wants a claim to be made that, you know, the certification may not have happened. And then the question is then asked, you know, am I able to go to CIPAA on this? Because I need the certificate for payment to be due and owing under the contract. This argument was raised in Binapuri, right? Essentially that the claim is not due yet, and therefore the contractor was not able to go to CIPAA. And the court said that, look, even if the contractual agreement between the parties provide for the issuance of such a certificate, the absence of certification cannot deprive the unpaid party from availing the adjudication process. Now, there were three reasons why the court decided on it. The main one was, look, you know, if the court would have decided otherwise, then obviously it would be very easy to frustrate CIPAA proceedings, you know. Basically, one can just refuse to certify. Second is that Section 25 allows for the power of an adjudicator to decide, notwithstanding the absence of certification. And Section 5 for the payment claim does not require a certificate. And Syarikat Bina Darul Aman just emphasizes the point that the claimant doesn't actually have to request the adjudicator to exercise this power. It's still fine for the adjudicator to decide to exercise this on his own. Okay. Now, Section 25O, this is on financing costs and interest. Very broadly, financing costs or known as financing charges, it's not defined in CIPAA, but it is thought to include the situation where there has been non-payment or late payment or incurred due to delay caused, not the fault of the contractor. And because of that, there's been increased costs in carrying out or completing the work. Now, there is a case which basically says that the contractor or the claimant, Quasatec, has to show a contractual entitlement to financing charges. So you must actually show the clause which entitles you to claim for financing charges. You must claim this in your payment claim, and you must prove that you have incurred this. For interest, the case of Zecon tells us that actually you don't have to show a contractual entitlement. And I think it's generally accepted that the adjudicators can grant this as part of the power under Section 25. Now, there is a discrepancy as to whether one need to request for it in the payment claim in the first instance, or can the adjudicator just grant it without any such requests. Milson Land, this case says that you don't have to claim for it in the payment claim, and the adjudicator can still claim for it. This is contrasted by the case of NASA Engineering, where the High Court actually decided that, look, you must claim it in the payment claim, because if not, the adjudicator would exceed his jurisdiction, right? And you read this with Section 27(1) and Section 5(1). That was the logic of this court case. Now, MRCB Builders is a case where the court tried to reconcile the two cases. You can see it in paragraph 81, where the court considered the case of Milson Land. Star Builders is something a little bit different, but where the adjudicator decided on a different timeline that was pleaded in the alternative. So the court looked at the cases of Milson Land and NASA Engineering and basically thought that there is no need to claim it in the payment claim, right? The adjudicator would not exceed his jurisdiction in allowing it. And the court distinguished NASA Engineering on the basis that that case, the factual matrix of that case was a little bit different, because the adjudicator had awarded multiple pre-adjudication decision interests. And if the fourth pre-adjudication decision interest was allowed, it would result in unjust enrichment. So that's how the court ultimately decided on that instance. Last one, extension of time, and Mr. Oon has briefly alluded to it. So if there's a delay in the adjudication claim, adjudication response, adjudication reply, then the adjudicator is able to extend the time allowed for submitting these papers. But the adjudicator cannot extend his own deadline for submitting the adjudication decision. That is, I think, quite accepted. Even if the adjudicator is late 1 day or so, the whole decision unfortunately goes. And these are essentially the cases that deal with that. So I'm going to stop sharing now and hand it back to you, Leon, for questions. Thank you.
Yes, thank you, Janice, for taking us through like a bullet train, but we are still able to get quite a lot of the gist from you. Now, I'm going to ask Miss Marshall, to let us know what are the questions that have been put forth by the participants. Marshall?
All right, hi everybody. I've got a question from the floor. I'll just read it out to the panelists and anyone can feel free to answer. The question is, must adjudicators negotiate the cost upon its appointment before issuance of Form 6 with the parties, although there are proposed standard fees from AIAC? Is this not allowed under Section 25, Power of Adjudicators?
Any one of you would like to take the lead? Engineer Wood, you have been taking a rest, so let's start off with you. Can you unmute yourself?
Sorry, I thought that was a standard practice of most adjudicators, right, upon appointment. Okay, the first letter he or she writes to the parties will be his proposal of the fees. Okay, and the only thing is when there's a disagreement by one or both parties to his proposed fees, right, then the default fees, scale of fees in AIEC will apply. So exactly where the question is coming from, I am not too sure on this.
Just chiming in on that one, it's not under Section 25, Power of Adjudicator. It's actually under 23(2) of CIPAA. Essentially, when the adjudicator gets appointed, you are allowed to negotiate your terms of appointment to be the higher scale one, which requires parties' written agreement. So that is the timeline that you are able to negotiate your terms of appointment. And of course, if parties don't agree, then you result back to the standard fees of AIEC lah. But the adjudicator does have that timing pursuant to 23(2) to negotiate the terms of appointment.
Shirley, any input from you, Shirley?
Yeah, I think just one point, because I think the question posed is whether this is allowed under Section 25. I don't think there's anything under Section 25 that is relevant to this issue.
Yeah.
I concur with that.
Yeah. I mean, we often find that it depends on the size of the claim. A lot of times, if the size is small, I would probably think that the counsel or even the parties themselves will say, let's keep quiet, wait until quite near to the, or don't even respond. So if you are the aspiring adjudicator, you will probably on the last date, the 10th day, adopt the record standard scale and put forth your letter of proposal on your appointment. That's what's happening, I think, in most cases. Of course, you have got some very experienced counsel or claim consultant, even for, not to be offensive, even for big cases, they keep quiet and, you know, if you are keen to proceed, you would adopt that standard scale. Yeah. Okay. Do we have a second question, Marshall?
We have one more question that says, can an adjudicator's decision be enforced even if an appeal or application to set aside is pending.
Okay. Shirley, you want to take that?
Yeah, can I, Marsha, can I just trouble you to repeat the question again?
Oh, yeah, sure. The question is, can an adjudicator's decision be enforced even if an appeal or an application to set aside is pending?
If the question is asked in the context of whether the enforcement, so you have enforcement and a setting aside, so both has been heard. I assume setting aside was not allowed, enforcement was allowed, and then the appeal is on the setting aside that was not allowed. So the question is, can you go ahead to enforce it? Sorry, I'm not sure whether that is the context of the question, but if that's the question, then if there is no stay, then obviously the party that obtained that enforcement order can proceed to execute it.
Okay, Un, what's your take on this?
I'm not sure whether the question asked is, okay, when you say enforce a decision, right? What does that mean? Is it a Section 27 enforcement? The practice is usually, right, okay, the stay application, setting aside application, enforcement applications usually are heard right together. So how does that scenario actually arise? Okay, I'm not too sure.
Yeah. Okay. All right. So, what do you think, Janice? You
Again, I actually echo what they're saying. I don't think this situation should arise lah. If there is an enforcement application, the court would consider the setting aside first.
Okay, that's the only question we have.
Oh, okay. Okay, then I have a question for the panelists. We always face with.
By the way, do you have jurisdiction to ask questions?
I think being the moderator, I probably have lah. We discuss that after this session. I buy you a lunch, okay, or dinner.
Yes, bribery.
To allow me to ask. You know, we always have these problems with respect to application to submit a rejoinder. Now, what is the view of the panelists? Rejoinder means after the last adjudication reply, then the party want a rejoinder, after that a sure joinder. Now, what would you think this position would be? How would you react to this?
Can I recuse myself from answering this question? Because, okay, right now there's an application before me as an adjudicator to submit a rejoinder.
Okay, so you want to keep quiet about this lah? All right, buy you a bigger lunch or a bigger dinner lah. Anyway, Shirley, you have any idea?
I'm not challenging your jurisdiction to ask the question, and I think you do have the power to ask. So I'll answer your question. I think when it comes to the request to file a further reply after the adjudication reply, I think it always goes back to the party asking for that must demonstrate that what are the new issues being raised that was not already covered in history documents that require a further response. So it is really for the party making that request to satisfy the adjudicator that there are some new issues raised that actually warrant a further response. Because you can imagine after that, you will have to inevitably allow a further response. And, you know, you can't be, there's no end to it, right? So I think the starting point is that it must be there must be clarity in terms of pointing out what are those specific things, and to limit it to, even if the adjudicator allows that request, it has to be on the premise that those very, very defined items or points or dispute.
Yeah, so you would consider the factors, but would you also consider the time frame? You know, apart from the justification in terms of allowing it, what about the time frame? Because you have already 10.10.5, as Engineer Un has said. Now, how do you deal with time? Because does your period of writing a decision of 45 days, when does it start? Because it's in the act, it says it starts from the last date of a submission of the reply.
Right. Well, I think that would require the consent of the parties, right? If you want to extend time, right? But I think the problem is if you are not allowing, it really depends, I think, because it could very well be what the party wanted to address, adjudicator on. They are not substantial points. They're not, you know, it all depends on, and also the timing when that request come in, right? Is it like after 3 weeks, or is it immediately couple of days after the reply filed, and then the claimant realized, the respondent realized that new things raised? Speaking from experience, I have come across where opponents raised new items, and that actually prompted me to actually ask for the right to reply. But I don't do that just because of, you know, trying to delay matter, but really pointing out where those new terms are. In fact, setting up in a table to the comparison.
Engineer Leon.
Yeah.
At the risk, okay, of showing whatever you call, can I just venture some ideas here and views?
Yeah.
Okay. Firstly, right, adjudication response. Adjudication reply, right? Okay. Now, under the Act, specifically say adjudication reply must answer to the adjudication response.
Correct.
So, if an adjudication reply contains new issues having been raised, so that itself, right, okay, is tantamount to me, may not be in accord with the provision or not compliance with Section 26 form content, so to speak. So, looking from that perspective, okay, it shall be treated as irregularity, as I said just now. However, right, under Section 26(2), the adjudicator, right, can so-called set aside the adjudication proceedings. Now, the question is, setting aside the adjudication proceedings, right, can they set aside that part of the adjudication reply that has already trespassed to other areas or has raised issues, right, which shouldn't have been raised in the first place? So if you look from that perspective, right, okay, and bearing in mind that CIPAA has no provision for the submission of a rejoinder, and also with the time limits imposed, as you correctly said just now, for the for the adjudicator to come up with his or her decision. So from there, okay, I think we can draw an inference as to what should the answer be.
Yeah. Well, I mean, we look at when will esteem was decided, everybody was jumping and say, look, you know, the matter was not raised in the payment response, but the respondent then raised many things, many issues and many matters in the education response, which the claimant then has to reply. And in his reply, there would be, I'm not sure, new documents, new evidence, which then justify the respondent putting up its rejoinder. So if you do not give that opportunity, would it not be a breach of natural justice?
But the documents, okay, are just the evidence for the reply to the issue raised in the response.
Yeah, I mean, this is what it is, and that is something.
It does not tantamount to new issue having been raised, so to speak.
What do you say to that, Janice? Are you following the argument?
Yeah, I think the way I approach it is slightly different. It follows on from what Shirley says. So Shirley has talked about looking at timing, justifying the reasons for it. I would just add the materiality of that, because obviously if the adjudicator declines on issuing or allowing the rejoinder, one is liable to be challenged in the setting aside stage for breach of natural justice. And one of the main things that are always looked at is, would it have been a material breach, right? Would it have made a difference in the adjudication decision? So I think that is something that needs to be looked at as well, because obviously the claimant has 2 rounds, right, to reply. And if something really substantial comes in the adjudication reply, and that would have materially changed the decision, then I think the adjudicator really must grapple with this issue lah. Yeah.
Agree. Okay, all right, good. Marshall, any more questions coming in?
No more questions.
Well, can I put in the last question for the panelists? We always,
Yeah, sure, go ahead.
sorry? We always faced with issue about the last section 25P, extension of time. How would the panelists deal with this extension of time, either to submit in itself adjudication claim, and then the respondent would also want further extension, and on top of that reply, they would want further extensions. How would the panelists deal with this? Before they even get on with submission, first response in agreeing with your fees, they already asked for extension of time. Now, are you able to, even if the parties agree, is that contracting out of CIPAA or not? Janice?
For me, I think you always have to look at the reasons, right? Why they're asking for EOT. They could have a real reason for asking for the EOT. For an arbitration, I just gave deadlines for something, and one of the parties just wrote to me, and of course, with the other side, to say that he had a medical emergency and he just needed more time. So I do think you need to look at why they're asking for the EOT. And then you have to weigh, as the adjudicator, are you able to complete your adjudication decision in time? For me, I think the practical way of going about it is, look, if you both want EOTs, you both need to give me an EOT in return, by way of consent. I would look at it in the merits and try to deal with it that way lah. Yeah.
Shirley?
Yeah, I think I agree with what Janice said. I think if your question is that, sometimes it comes out at the start, and I think that might be even easier, because if both parties are asking for it, then I think as an adjudicator, the next point would be, okay, I need, consequentially, I also need the extension of time, but if the question is not at the outset, let's say after adjudication claim was filed and then something happened, respondent needed more time, then of course it's always case to case. You really have to look at what's the reason, and also the duration. How long? Is it just 1-2 days, or is it going to be like 2 weeks? And of course that will have an impact to the subsequent timeline. So I think it has to be reviewed or considered case to case, and see what are the reasons for that.
Any view, Engineer Un?
Nothing to add on this.
I think we'll add on this side. Okay, all right. Marshall, 7:10, do we want to continue or?
No, I think we can end the session. I think everybody has been long enough on this call, but thank you so much for such an informative session. We learned a lot. Thank you for your time. Thank you, everybody, for tuning in.
Yes, thank you.
Thank you, Marshall. Thank you, Leon.
Yes, you've been very,
Janice,
very...
actually.
Thank you.
Okay, all right. Catch up with you guys. Thank you. I
Thank
owe
you so much.
Thank you.
All right,
And I'm
thank
waiting
you.
for,
Good
and
night.
I'm waiting for your lunch.
Thank you. I will. Bye-bye.
Bye-bye.